Would you give up your privacy for security? As you may know, in 2013, Edward Snowden copied and leaked highly classified information and top-secret documents from the National Security Agency, the NSA, to news outlets such as The Guardian and The Washington Post while he was working for Booz Allen Hamilton, one of the NSA's largest contractors for defense and intelligence. This information revealed massive surveillance systems, both global and domestic, run by the NSA and the Five Eyes Intelligence Alliance. While releasing classified documents, which by law and by country security measures is a distinctly criminal act, it can be argued the existence of the surveillance system themselves, not to mention the fact the public had no knowledge of them, are massive infringements of privacy and can be considered a breach of the Fourth Amendment of the Constitution. Snowden himself claims he had a moral obligation to release the documents. This video essay intends to focus on Snowden, analyzing his case in the context of the clash between the two key values of security and freedom. It will use ideals regarding privacy and surveillance, as well as historical examples of governmental surveillance misuse to advance an analysis regarding the disparity between these values in the modern digital age, and provide evidence that Snowden's actions were justified. It will aim to answer questions such as, is what the US did a violation of the Fourth Amendment of the Constitution? Did Snowden, in his own words, in fact have this moral obligation to release the documents, and so should he be protected under whistleblower rights, regardless of his previous status as government employee? While the Constitution of the United States does not explicitly note the right to privacy, it is alluded to in the Fourth Amendment, which prohibits unreasonable searches and seizures of persons, houses, papers, and effects. Effects refers to any and all personal possessions, namely physical property. However, considering how long ago the Constitution was drafted, these days it has come to include digital property as well. Though there is no explicit decision on the degree to which it does so, therein lies the problem. In October 2017, the Supreme Court ruled that the Fourth Amendment protects property interests as well as certain expectations of privacy, holding that when an individual seeks to preserve something private, and his expectation of privacy is considered generally reasonable, official intrusion would qualify as a search and seizure and would thus need a warrant supported by probable cause. Specifically, they ruled that a law enforcement agency could not seize digital location records of bank robbery suspects without said warrant. However, the court noted the decision was a narrow one, which limits it in scope. Either way, it is important to note the probable cause aspect required in regard to the warrant when considering the case of the Snowden documents. In the court case above, the individuals whose digital locations were seized were alleged bank robbers, and even in their case it was ruled the government needed a warrant to spy on them. The documents Snowden revealed detail that the NSA collects data about anybody, regardless of whether or not they're an alleged criminal. Data that comes from cell phones, laptops, Facebook, and other social media platforms, chat rooms, and more. All this information comes together to build data patterns of life, surmised as a detailed profile of a target and anybody even roughly associated with them. The Guardian reported the agency is allowed to travel 3 hops from its targets. These targets include people who have interacted with people who have interacted with you. So this means that if you have a mere 100 friends on Facebook, which is less than the average, these 3 degrees of separation lead to a network of more than 2,500,000 individuals. Thus, if any of those 2,500,000 individuals are flagged, your information will be recorded and flagged due to your association with them. Even ignoring the fact that there were no warrants issued for the individuals, is there really probable cause for the NSA to be surveying hundreds of millions of Americans? Over the years, there have been additional U.S. laws in place to prohibit agencies of intelligence from targeting American citizens. The National Security Act of 1947, which, in establishing the Central Intelligence Agency, or the CIA, and the Department of Defense, or the DoD, clearly prohibit the agency from having quote-unquote police, subpoena, law enforcement powers, or internal security functions. End quote. Again, considering how long ago this act was passed, it did not and could not have taken into account the digital advancements that would allow for state surveillance, but the sentiment remains the same. The idea was that the United States needed intelligence operators in case of foreign attack, but that the element of domestic surveillance overstepped boundaries. What can be considered justifiable surveillance/information gathering has historically been the difference between foreign and domestic. Whether or not it is right, it is generally understood that nations spy on other nations. But that line has become increasingly blurred, especially as the majority of the communication infrastructure in the world has come to reside in the United States. As noted in the PRISM program leaked by Snowden, this gives a significant home field advantage to the United States in its surveillance capabilities, allowing for easy access to domestic targets. Unfortunately, the documents and surveillance programs Snowden leaked were not nearly the first instance of the federal government spying on its own citizens. Project Shamrock was an NSA initiative started in 1945 to analyze and record all incoming and outgoing telegraph communications. While it included foreign communications, it also included a vast amount of communications to and from American citizens, domestic. In a 2012 review of NSA programs that affected Americans, intelligence officer Major Dave Cohen wrote that, quote, "The companies involved in Project Shamrock questioned the legality of these activities, especially in peacetime," end quote, and at its peak, the project collected approximately 150,000 messages per month. Company representatives met with the Secretary of Defense in 1947 to discuss their continued participation in the program, and 2 years later in 1945 again brought up the same concerns. Yet each time they were told the project was, quote, "in the highest interest of national security," end quote, and that its purpose was to improve the foreign communications intelligence mission. Project Shamrock was later terminated in 1975 amongst increasing congressional concerns that the data collection was, in fact, in violation of the Fourth Amendment. In the same review, Major Cohen also wrote about the U.S. State Senate Select Committee to Study Governmental Operations with Respect to Intelligence Activities, better known as the Church Committee. From 1975 to 1976, they investigated the NSA's programs that affected American citizens. Following a thorough investigation, the committee issued the report National Security Agency Surveillance Affecting Americans, which argued the lack of a statutory declaration or other significant means of control constituted an unacceptable risk to the Fourth Amendment rights of American citizens. The report was rather effective in demonstrating the potential negative effects of intelligence agencies collecting mass domestic data, and led to increased legal restrictions and oversight procedures on the NSA's foreign intelligence authorities, the most notable of which being the Foreign Intelligence Surveillance Act, or FISA, of 1978. It explicitly defined the rules and regulations for physical and electronic intelligence surveillance activities, most importantly making an authorized warrant mandatory for electronic surveillance of foreign agents, and in some instances heightened requirements for U.S. persons that were targets. However, the PATRIOT Act of 2001, which was passed in response to the tragic events of 9/11, essentially threw the rules and regulations of FISA out Fort Meade's window. Section 215 of the PATRIOT Act contains a business records provision, which gives the government vast power to ask businesses for their records relating to someone who might be involved in terrorism. Emphasis on the might. When the act was first passed, this section was slightly criticized due to fears that the government was going to force public libraries to turn over individuals' borrowing records. Unfortunately, as leaked by Snowden, under the PRISM program, it was revealed the government was using Section 215 as justification for something much more invasive, collecting the phone records of every single customer of multiple phone companies, including Verizon. Internet companies were also mentioned in the leaked documents, including Microsoft, Google, Yahoo, Facebook, Skype, Apple, and others, meaning that the data collected was not limited to phone conversations, but allows the government to obtain email, voice and video chat, photos, voice over IP chats, file transfers, social networking details, and more. This program allows the NSA, which is incidentally the largest surveillance organization in the entire world, to obtain and keep record of any and all of these communications without having to obtain individual court-ordered warrants or even request them from the service providers. They can actually reach directly into the servers of these major companies and even perform real-time data collection on a given target. The NSA claims that PRISM was adopted to overcome what they regarded as FISA shortcomings in tracking suspected foreign terrorists. Mind you, the threat of terrorism is real. Protecting our country against suspected foreign terrorists is certainly something that should be done, especially in the advent of 9/11. Keith Alexander, director of the NSA at the time, pioneered the NSA's collect it all approach to data surveillance and upholds his agency's pronouncement. I quote, "If you have nothing to hide, you have nothing to fear." End quote. He told an audience at the Black Hat Cybersecurity Conference in July of 2013 that the PRISM program has, quote, helped the FBI stop 54 terrorist attacks in the US and other nations, end quote. Were this really the case, the need and justification for the program would seem considerably clearer. However, in January 2014, when the government's Privacy and Civil Liberties Oversight Board reviewed the PATRIOT Act, and specifically Section 215, as well as the operations of the Foreign Intelligence Surveillance Court, the FISC, the results were in clear contrast with Alexander's comments. Quite the contrast, in fact. Quote, "We have not identified a single instance involving a threat to the United States in which the telephone records program made a concrete difference in the outcome of a counterterrorism investigation. Moreover, we are aware of no instance in which the program directly contributed to the discovery of a previously unknown terrorist plot or the disruption of a terrorist attack." Not even a single instance. Not one. While protecting our country against terrorist threats, even potential ones, is a valid and necessary idea, for the government to be doing it in this manner, infringing on the privacy of hundreds of millions of its own citizens, and to not even have a single instance in which the program was deemed to serve its alleged purpose? Not only is it a huge waste of taxpayer dollars, it's a massive blow to the state of our democracy as a whole. To go back to Snowden for a moment, the United States government responded to his revelations exactly as he anticipated. accusing him of illegality, espionage, treason, and using its imposing resources to discredit and severely punish him. He is charged with theft of government property and 2 accounts of breaking the Espionage Act. And yes, what he did was technically illegal. He has publicly admitted that as a contractor for the NSA, he signed the standard obligatory government classified information NDA or non-disclosure agreement, meaning that his actions can be construed as a violation of a quote civil contract that he entered with the government. But as William E. Scheuerman, professor of political science at Indiana University, noted in a June 2014 research article concerning Snowden's actions as that of civil disobedience, quote, "Though Snowden admits to having violated the standard government non-disclosure agreement, he has violated prohibitions on whistleblowing only because doing so offers an effective and, in his view, necessary way to bring the injustices of U.S. surveillance policies to public attention." End quote. Essentially, although yes, what he did was in violation of the law, doing so was necessary. The NSA's defense of its actions as legitimate come mainly from asserting the secret rulings of the FISC, court proceedings which the world is not permitted to see. However, as Scheuerman notes, considering what we know regarding the lax judicial oversight of the NSA, mind you, the FISC's own Chief Justice has conceded that the court is badly equipped to perform its job, and the evidence that the NSA often blatantly ignored or circumvented the court rulings, when these examples of secret jurisprudence, irresistible executive power and discretion, and arbitrary power come together, they need to be countered by whatever means available. Taking into account the idea of necessary security, the historical examples and precedents of government surveillance in the United States, as well as the associated laws and acts outlined, the scope and type of data obtained and recorded under the leaked NSA programs, the weak justification for the existence of the programs, as well as the proof they were unsuccessful, a fact lied about by the director of the NSA, not to mention that the public was not in the slightest aware of them in the first place, Edward Snowden's actions to foster an informed public and promote an open democracy appear justified. In the 1970s, Project Shamrock was terminated because of concerns it was violating the Fourth Amendment. And all it did was record telegrams. Despite this, and the many other examples and acts regarding privacy in the United States, the government decided to initiate a program with surveillance and data collecting capabilities light years beyond what was previously terminated for breaching the Constitution, and use an act proven to be effectively useless as justification. Despite all of this, we have no evidence that the NSA ever ceased the programs outlined in the Snowden leaks, which is a terrible precedent to set, as technology and the potential for mass surveillance only get more and more advanced. Not only that, but the technological advancements have also led to a recent rise in self-surveillance, what with the advent of Alexas and Google Homes and other smart devices. In conclusion, although Snowden achieved starting a global dialogue regarding privacy and surveillance in the modern digital age, that dialogue has slowed down in recent years as people move on to other issues, and in the eyes of the government, Snowden's still a wanted criminal. If this is the precedent set for our democracy, that even when an issue with this amount of weight is brought up, nothing is done about it and it is merely slowly forgotten about, as technological advancements continue, we could be facing a much bleaker, essentially Orwellian surveillance state in which the very notion of privacy is completely foreign.